Hello, everybody. I guess, or one person. I am just waiting for the first question. So I'm going to be doing some work until I get the first question. I just had a little extra time today. So I thought I'd go live and answer some questions. All right. We have a question from Bianca Bowles, who says, hello, I got a question. We ended up doing a right to sue. So I think you got a right to sue from the Equal Employment Opportunity Commission and then taking the case to federal litigation. However, the federal court system is asking for mediation. What are the steps for that? I watch almost all your videos and it has helped me through anxiety attacks all the time. Bianca, I am so glad to hear that the videos are helpful. That makes me super happy. We actually have a whole mediation preparation playlist of videos that I'm going to grab for you right now, and I will link in the chat. Hopefully it helps. That's going to be a bunch of videos that specifically deal with this topic way better than probably I can provide you in a live stream. So let me get you those videos. We have too many playlists. I'm still looking. My gosh. It's easy to lose track of how many videos we've created. There we go. I found it. All right, Bianca, I am linking it in chat for you. That is the mediation preparation playlist. I really hope it helps you in some way. John Doe KCK says, how are the chickens on your farm, Vince? Hopefully you're getting more eggs than you imagine. So super exciting. I run two different kind of chickens. So I run for meat, Freedom Ranger chickens. The breed is Freedom Ranger, and they are meat birds. And I raise them and we process them, and they make these amazing roasting birds. Super good. So we did a good number. We raised a good chunk of the meat rangers, and they're like, they're like, I don't know, 10 to 15 pound range, maybe closer to 10. And then we keep a couple breeds, a lot of Rhode Island Reds for the egg layers. Got about 40 of those going right now. And I just moved them into their winter enclosure. In the spring and summer, I let them like wander the property and like eat all the ticks. Ticks are a big issue in rural New Hampshire. But we have a real fox and coyote problem, and hawks and fisher cats and a variety of other predators. So for, the colder months, we push all the egg layers into a kind of a fortified enclosure. It's really big. It's spacious. They love it. And it keeps them warmer in the winter. Starting to get cool up there now. So they're pretty happy. It keeps them warmer in the winter. Starting to get cool up there now, so they're pretty happy. Thank you for asking. I love talking about my chickens, John Doe. I hope you're well. We have Novek Atwad, who says, I have a civil case against my son's elementary school as well as middle school. Can I list the teachers that they were involved? So, Novek, I can't give you necessarily legal advice about this because I don't know where you are. Generally speaking, if the teachers are bad actors, you can probably include them as parties in a lawsuit, but check with local counsel. And also, Novek, I'm an employment attorney, so I'm not the best person to ask about this. We have a question from Black Anime Geek, who asks us, why would the employer mention an employee was very critical of the company in their position statement? Black Anime Geek, they mentioned that the employee was very critical of the company to make the employee sound like a complainer who talks a lot of shit, who they had another reason to get rid of that was not discrimination or retaliation. My story is still being written, says, thanks again for your time. My pleasure. What is the average time frame to draft the complaint to file in federal court? 90 days have started, and the time is of the essence. So on average, a first draft can take around 2 weeks. Revisions are much quicker, probably 48 hours in most cases. Listen, I've seen firms take 6 weeks, but I generally say, like, listen, give us a comfortable 2 weeks to get this done. Listen, worst case scenario, can it be done in 4 hours? Yeah, it can be done in 4 hours. It's not great for the attorneys, and the work product is not as polished as you want it to be. You know, it's just a rush job. We have Star Michelle Star, who says, hi, the company I'm suing wants to settle instead of mediation. The number was low, so I'm pushing for a higher number. They're willing to settle. Do you think they will raise it a bit? Yeah. Listen, if they want to talk turkey, they'll probably, have a negotiation with you. If you're demanding they come up, then yeah, sure, why not? I think that's very reasonable. Philip Morning One asks us, hi, Vince, question. How does a civil discrimination complaint turn into a criminal one? I mean, the simple answer, Philip, is that you file a police report and press charges. If something criminal was done, right? So, like, I'll give the classic example because we have a lot of these that happen. Like a workplace sexual forcible touching happens a lot. There's a lot, and these range from like the creep trying to massage the woman in the office to listen, the mentor getting his young mentee drunk and taking advantage of it, right? Like, you see all this stuff. But you'll note that both of those could have criminal charges attached, right? Like the creep massaging, that's a forcible touching. Now, if that woman indicates, hey, don't touch me anymore, and he continues, this is now, I would argue, in many jurisdictions, a sexual assault criminally. Check with local counsel. And the example of the mentee whose mentor, gets her maybe too drunk to consent and then takes advantage of her, that is, of course, rape, right? She doesn't have the capacity to consent. She's too drunk to consent. So that is rape. That is a criminal charge, no question. And you would file the criminal charges in parallel with the civil case. Awamihi says, if you feel like you have a strong EEOC case, evidence and rebuttal to employer's position statement, but the case is still in investigation stage, should you or can you ask for mediation to settlement? Yeah, absolutely. If you want to talk about settlement, you can just make a demand or you can ask for mediation. I see no reason why you wouldn't. Phoenix 1992 says, hey, Vince, I'm currently in a lawsuit at the EEOC. My lawyer says we are waiting for a response to the lawsuit. He said it can take a while for them to respond. How long? The lawyer says we are waiting for a response to the lawsuit. He said it can take a while for them to respond. How long can a response take? So, I mean, it depends on your jurisdiction. In New York, I believe if they did waivers of service, they get 120 days to answer the lawsuit. So that's the New York-based answer, and it's conditional if they did waivers. If they were served, it's quicker. They don't have quite as long. Black Anime Geek says, but it wasn't that at all. they asked the employees for ways to improve the department in a meeting. How would an employee combat that? Black Anime Geek, I don't think you have to worry. Like them saying somebody was critical of the company is not like a great defense for them to raise. It's just a defense. Like it's an attempt to cloud the issue, to make a defense. It's not a great argument. YouTube user Devin says, good news. I was able to file pro se. Congratulations. The judges granted me the waiver thing. I forgot the name, which helped me not to pay the $405 to submit the complaint. At the moment, the pro se office has helped. I'm really glad to hear the pro se office has helped. I hope that I was the one who sent you the pro se office, and I hope that I created some content that was useful to you in some way. And I hope further that you get paid. Chris Ritchie, parentheses, adventurous, parentheses, says, New Jersey. What? Christopher, what kind of adventurous are you? Never mind. Says New Jersey courts rule that an Uber rider can't sue the driver due to arbitration clauses. Well, Chris, they can bring the arbitration. They can't sue. I see a question was deleted. I'm not going to say the name, but if you want to email that question to me, I hope you know I'm always thrilled to have these conversations with you. YouTube user JD says, hey, Vince, obtained counsel, just received the right to sue letter, and my attorney is now submitting a letter of demand. How good of a chance of settlement with a 30%? How good of a chance of settlement with a 30% risk in a constructive discharge case? JD, I don't know anything about your case, so I can't tell you what the chances of settlement are. I don't know your ask. I don't know what the damages are. I don't know your liability. I don't know what the claims are. I don't know your jurisdiction. I don't know your jury pool. I don't know the attorneys involved, right? Like there's so many things. Like if you're bringing a case and Jackson Lewis is defending it, chances of settlement are way up because Jackson Lewis is a budget option and they want to often, they're hired, they're brought in to settle cases, right? So like there's a lot of stuff like that. M. King says, hi, Vince. Oh, SCK 4110 says, thank you for everything you do for us, supplying so much needed information. I hope I help, SCK. M. King says, hi, Vince. I have a pending MCAD case riddled with conflict of interest. The employer has 3 attorneys, 2 of which were former employers. What does that suggest about the firm and the MCAD? Well, I'm not going to comment on the MCAD, but if there are actual conflicts and the attorneys are pursuing the case anyways, then that raises some questions about the firm. But I mean, you always have to be careful when looking at conflicts to make sure the conflicts are conflicts under the ethical rules, right? Because they might be doing their own research on their end and thinking they're going to get away with it. And it's possible they could be right. YouTube user Pamaroon says, given Cassie's past civil court settlement and potential testimony in Sean Diddy Combs' criminal trial, what legal precautions or strategies might prosecutors and defense attorneys employ to address? Pamaroon, I am familiar with one of the attorneys who worked on that case, and I should reach out to her and see if she wants to come on the channel. She's swell, and she was or is one of the few female partners in a plaintiff side employment law firm in New York that I'm aware of. I'm aware of 2 in the entire state. I'm sure there's more on the plaintiff side. I just don't know them. No, 3. I just thought of another one. But too few, way too few, right? So I should reach out to her. Hello, Noriega, one of the last ones. I always love your username. All right. Do we have more questions? More questions. I've got answers if you got questions. And again, folks, this is going to be a quick one today. I got to drive to New Hampshire. I just got a little bit of extra time. I have a late Zoom that I have to take at like 6 something. So I got to sit around, wait for my Zoom. And I figured I would get on and answer some questions. Do we have any more questions? Oh, we got more questions. This is exciting. All right. Novak Atwad says, how often do you go live? I'm trying to go live once a week. I'm probably going to go live Friday afternoon as well. After I get off here, I will post the link for the Friday afternoon live stream. I need to go live more often. It's like become clear to me that a lot of people who don't ask questions in the comment section will ask them in a live, and that just kind of makes sense. People prefer the interaction, even though the questions and the answers are much shorter here. So I'm going to try to go every week. YouTube user Anthony says, "Hi, Vincent. Your videos have been very helpful as a law student." Oh, that's amazing. Who's going into labor and employment law. For my post-grad job, I am joining one of the 4LE shops. Do you have any tips as a new associate? We actually have a playlist, Anthony, for young attorneys. Listen, I don't know your situation. I don't know what kind of firm you're joining necessarily, or what, the compensation model is. I would say that this. Get the nicest suits you can comfortably afford. They matter. And determine the priority of your various skill sets that you want to work on. Like, right, there's legal drafting and research. There's soft skills, negotiating, working with the press, controlling public opinion, right? Like there's a lot that can be done there. There's are you a procedural litigator? Are you a trial attorney? And clearly you need to work on all those skills. You need to be a full package to some extent, but you will also, I think, specialize generally a little bit, and you should give some thought to prioritizing what kind of attorney you will specialize into, right? Like, it obviously an employment attorney, I think, is what you're saying, but like this firm, we have trial attorneys, we have soft skills attorneys, we have procedural litigators who duke it out in motion practice, and it's just we have research and writing attorneys, so it's and we feel strongly that combining those teams makes for a better end product for our clients. So if you subscribe to that pattern of thought, that train of thought, I would urge you to like assign. There is someone shining a laser. Am I going to get shot? Well, I had it coming. I would prioritize I would prioritize what skill set you work on first. I hope that helps in some way, Anthony. What do we have? We have YouTube user Phoenix 1992. Hey, Vince, is it true it'd be hard to seek damages for another male coworker saying sexual comments about my disability if he was male and I'm straight? It's wrongful termination on FMLA, but I was wondering. I mean, listen, heterosexual male, sexually harassing heterosexual male. I'm not going to lie to you. It's not the best claim, but it's not a claim, right? Like that is a claim of sorts. It's probably not your biggest claim if you're dealing with an FMLA case that's pretty well built out, but it might be something you include. Like, why leave it on the table if you don't? But it might be something you include. Like, why leave it on the table if you don't have to? John Doe KCK says, speaking of Puff Diddy, way back when I lived in NYC before he bought Ciroc, I remember him forcing his way into a club with his own bottles of Grey Goose rather than buying legit bottle service. I don't know the guy. Obviously, I'm not familiar with Mr. Diddy. However, I will say that as New York goes, that does not surprise me at all. I'm not even commenting on Mr. Diddy or what he did or did not do, the allegations against him. But I will say that, like, and I'm not a club fella, but I worked in bars for a decade, and the percentage of like wealthy people who want or like feel the need to sneak bottles into clubs in New York is insane. Like, it's very strange to me, because the whole point is to like stunt, like, look what I can buy. And there's like people in their group like sneaking bottles out of purses and stuff. You're just like, really? Like, this wasn't the point to show money? Like, what are we doing? YouTube user Kobe Lamont says, how would you suggest a law school grad get started in employment law? any previous experience one should get. So I would say the Unemployment Action Center, which is a clinic that represents people who need help with unemployment cases, and I believe is nationwide, is a great option. Whenever I see that on a resume, it piques my interest because you're doing actual unemployment hearings, which, listen, they're not complex hearings, but they're practicing employment law in a trial hearing setting, right? So that's pretty great. I would intern at plaintiff's firms, right? If you want to work at a plaintiff side, you should. If you want to work on the plaintiff side, you should intern at plaintiff's firms. If you want to work defense side, you should intern defense side. Generally speaking, a lot of people go plaintiff side to defense side over the course of their career. Not many people go defense side to plaintiff side. I've seen it happen. I can think of one gentleman who did that, but like the fact that I can only think of one is pretty telling, right? It's hard when you get that like big law defense firm, 400, 500, 600K. It's hard, I think, because you grow into spending that money, right? There's expense creep in your life. It's hard to be like, well, yeah, I could win more, right? If I go plaintiff side, I got my percentage, and I'm a damn good attorney. I'm a defense big law attorney. People pay me $1,600 an hour, but like, you got to win. And defense side, you don't got to win. You just get paid no matter what. So I would start off on the side where you want to work. My suggestion. YouTube user Nia Knows Best says, you answered my question months ago about my job not believing my anxiety. My lawyer submitted a letter to them. Their lawyer got back and said he was advised to solicit a settlement demand. That's incredible, Nia. I hope that you make a good demand and you get paid. Pedro Pin advised to solicit a settlement demand. That's incredible, Nia. I hope that you make a good demand and you get paid. Pedro Pineda, I do not take email questions. There was someone specific I said that to. If you want to ask a question, you can put it in chat here or you can comment it on a YouTube video. I actually can't. I don't have the capacity to take the volume of emails we receive and answer them. It's gotten beyond what I can do. And I like briefly was like, I should hire someone to respond to this email. And then I realized like that someone would have to be an attorney because they can't answer legal questions without being an attorney. And the idea of me hiring an attorney just to answer emails to people was a non-starter. people talked me out of that real fast. YouTube user JD says, understand. Thank you. Former employer is a 12,000 plus employee company and my hired firm is big time in Ohio. I guess my real question is, how serious are constructively discharged cases taken on average? So JD, I would say this. Constructive discharge arguments add risk. They add some risk to a case. That's it. That's the only thing. It's just a little bit of added complexity and a little bit of added risk. I do not feel that constructive discharge is a deal breaker. It is added risk, added complexity. That's all. Princess Diara says, I have a promotion discrimination case with the EEOC that's eligible for early settlement. Am I required to participate in mediation? The employer has not responded to my demand. No, all mediation at the EEOC level is purely voluntary and you are not required. I have a mediation preparation playlist that really hammers home the idea that like mediation, if both sides agree to it, is valuable and you might want to go, but you do not have to go. Tang Nguyen says, hello, Vince. My retaliation and discrimination lawsuit on unlawful termination has been filed. My attorney advised to not disclose the lawsuit to the news press. What do you think about the press? Okay, so this is kind of a big part of what I do in my practice, controlling public narratives. Going to the press is a single shot thing, right? Like if you're familiar with like the world of Sherlock Holmes, where people had these single shot pistols called Derringers, it's a pistol with like one shot. And once you shoot it, it's done. It's going to take you like half an hour to reload it. And they were like self-defense weapons, circa like Sherlock Holmes. Think of press in much the same way. You can only do it once. And once you do it, you can never put it back. If you shoot somebody, they're dead. You can't undo it. But also, you can't put the bullet back in the gun. You can't use it again. It is done. So if you want to do press on a case, You need to think very carefully about when to do it. And you also need to be very careful about how you do it because, listen, press can push settlement. It can also push parties away from settlement. It also can get folks into trouble if they do the wrong things when they're trying to do press. So, one, talk to your attorney, see if your attorney has experience with press and managing that rodeo, right? But also have meaningful conversations about, well, how is this going to help us? How are we going to use this? How are we going to keep this ethical? How are we going to do right by the laws of the jurisdiction we're in? What are the concerns and what are the advantages and like what's the timing? When is the time to do this? And when will it help us the most? And when will it have the most control of the narrative, right? That's important. Nia Knows book says, is it normal for it to take a while for the company to respond? Or can they just ignore it? It's been about 1.5 weeks. 1.5 weeks is not a long time for a response from company. Listen, I don't know what you sent them, but if you sent them like a complaint that's not filed yet, they don't have to respond at all. If you sent them like an EEOC filing, they're going to get significant amounts of time to respond about mediation or to respond with a position statement, things of that nature. Taking one moment to check my emails. All right, I am back, and I apologize. I had to answer my emails. Okay, we got questions. What do we have? Chat jumped ahead. SEK 4110 says, if the EEOC decides one is eligible for early mediation, can you tell us approximately how long it will take before you receive a date for this to occur? SEK 4110, you are waiting to see if both sides agree to mediation. EEOC mediation is voluntary, so they both have to agree. If you both agree, I think you'll probably find out within a month. YouTube user JD says, I've watched many of your videos. I hope they were helpful. You helped me understand so much of this confusing and intimidating time in my life. Thank you. JD, I hope I helped in some way. Sincerely. Philip Morning One asks us, what is harder? Go at it pro se or pass the bar exam without going to law school? I assume you try very hard. At both. So, Philip, law school is not actually very useful for the bar exam. I would argue that everyone in this channel could pass the bar exam with an 8-week primer course. The primer courses for the bar exam are pretty amazing, in all honesty. And when I took it, so I think times have changed, but when I took it, it like came just on an iPod. Like there was a specific branded iPod that came with all the stuff that I had to listen to get ready for the bar exam. And I did my bar prep. I like got a place at Cornell. I did not go to Cornell for law school, to be clear. I don't want any stolen Cornell valor. But I just know I love the Cornell area. Ithaca is gorgeous, right? It's a beautiful area. And it was the summer in Cornell when I did my bar prep. And I was like, oh, that'd be a cheap place to get an apartment to do my bar prep. So I grabbed an apartment there, met some super cool people because all the international students stay on campus in Cornell. So I met people like a friend named Vanina from France who was like super cool. We hung out that summer. She was also doing her bar prep. And you just go, and I would just listen to my iPod filled with lessons for the bar exam. I did not find it onerous, and I passed with like there's like a requirement where you get to waive into 4 states if you do well enough on the bar, and I hit that requirement, which is like the highest meaningful requirement. You can certainly do better on the bar exam than I did. That's not what I'm saying, but like the last meaningful requirement is you can waive, or at least at this time, was you could waive into 4 states if you did well enough, and I hit that requirement. 4 states at once is not bad. And then after you practice for 5 years, you can pretty much waive in everywhere. What do we have? Harlem World Baby. YouTube user Harlem World Baby says, if you cannot find representation and you need help filing pro se, is it possible to hire an attorney to help draft a pro se lawsuit? It is possible. It's not possible to hire our firm to do that, but I know that there are attorneys who will do that. Also consider the pro se support office. They may help you as well. YouTube user Open and Shut says, hi, Vince. It's been 1 year since my unlawful layoff. My famous attorneys are going to submit the demand letter soon. I have good evidence, and my attorney said mine is one of the most egregious. That's great. I'm glad you have famous attorneys. Open and Shut goes on. Most egregious cases versus all they are handling versus Wells Fargo, retaliation, race, and ADA discrimination. The company is the evil Wells Fargo. What kind of settlement is expected with a $300,000 annual compensation? So listen, I don't know anything Open and Shut about your case, but if you have a strong case in liability, like a really solid discrimination case, and you're making $300K a year, and if you want to settle, listen, I think you might want to make a demand of 3 years. But you could have discussions between 2 years and 5 years at that point, right? Like we just don't know enough about your case. I don't really want to speak out of turn. Probably a great conversation to have with your attorney. But that being said, Wells Fargo, I know Wells Fargo really sucks to work for. I'm sorry you had that experience, and I hope you get paid big money. YouTube user JH says, during mediation for settlement, how much talking do the clients actually do? Is it mostly attorneys negotiating? As the client, what should you expect? So I think if your attorneys are doing a good job, you should be speaking for less than 3 minutes total during mediation. Generally, I think forcing the client to speak during mediation exposes them to additional risk, and it also gives the other side a view for how good of a witness the client's going to be. And I don't want that, because most clients, and this is, listen, if you have the all-star witness client, which happens, right? Like, listen, I represented trial attorneys and actors and thespians and like reality TV stars, people who are like really good off the cuff and like they orate, and this is what they do. They tell stories for a living in a logical, well-communicated fashion. Great. Best witnesses in the world, right? Those people, maybe you have them speak at mediation. The other 99.9% of human beings, no, never, as little as possible, because you don't want the other side being like, well, listen, they got a good case, but can this person really carry the story? Like, most of it is going to be her or his testimony, and I think we can probably mess with them, and that is how defense attorneys think. YouTube user John Craig says, should folks wait for the ROI or ask to see an admin judge once 180 days has gone by from the initial filing? I think that would be situationally dependent. I don't think I can answer your question. I think it would depend on your situation. Tech 5280 says, I received my right to sue letter after a 10-month investigation involving discrimination and retaliation. My attorney wants to file a suit at the 90-day deadline. Why do you think that is? So if they're burning out the 90-day deadline, I guess they might be having settlement talks. Have they told you there's settlement talks and they don't want to file publicly? Is that the idea? Or like that would be the only reason that I could think why you would burn your entire deadline. Otherwise, get that case filed is my take. YouTube user D's just joked. Whoa, chat jumped ahead. YouTube user D's Just Joke says, I've done tons of research, and the company I'm suing for sexual harassment and retaliation doesn't have many of these case types listed. Could this be indicative that they will likely settle out? No, I don't think so. Open and shut forgot to include sexual harassment, and the location is San Francisco. I think San Francisco is a great jury pool, so that's great for you, open and shut. John Wong says, my lawyer sent a draft complaint to the defendant for a whistleblower retaliation case instead of a demand letter. Is this normal? He won't talk money until speaking with their attorney. Yeah, you don't put a monetary demand in writing usually because you don't want it showing up in front of the jury later, right? If a jury sees you asking for a settlement demand of like, I don't know, we'll call it 600 grand, right? The fear is that the jury will then be like, well, plaintiff wants 600 grand. Let's just give him 600 grand. When really that's a settlement number, not a trial number, right? If you're talking settlement, you're hedging for risk. So you're probably asking for less than you might win at trial. At trial, you're embracing all the risk, so you try to win more. But you don't want the jury getting anchored to your like hypothetical $600,000 demand, when in reality, you're trying to win a lot more at trial. And that demand letter could end up in a trial binder, could end up in evidence. And you don't really want that in front of the jury, especially if the evidence gets put in the deliberation room. Noriega, one of the last ones, said, have you ever heard of Friedman and Holding law firm? If so, are they pretty good? Well, let me take a look for you, Noriega. Let's see what I can do here. I am gonna check it out. I have never had dealings with Friedman and Holding. And I can't disclose what I know about them, is the honest answer. I apologize. Nor disclosed any of that, so I can't tell you anything. But I have no personal dealings with Friedman and Holding. NYC Damages. Hi, Vince. Would you consider going over EEOC settlement publications and comment on those? I am not thinking of any specific ones, but it might be interesting for recorded videos. Actually, NYC Damages, I was thinking that I owe the channel another EEOC statistics video if folks want to see it. But I Googled around for this year's EEOC statistics, the 2023 or 2024 statistics, and I didn't immediately see them. I hope they're still posting them. So if you or if anybody in the channel knows where the EEOC is posting those statistics now, please link me. I would love to do that video. That video, the first time I did it, was one of the most popular videos in the channel ever, and it seemed like it really helped people and also kind of activated people, like made people really angry. John Doe KCK says, can going to the press in a case possibly hurt a plaintiff's chances of getting future employment? Yeah, absolutely, John Doe. That's a great point. So when you do press, that's out there forever. Like, it gets syndicated, Google picks it up, the Wayback Machine picks it up. Like, there's no getting rid of those stories, and they're going to have your name in them. So every time a future employer does a background check or even just Googles your name, those stories could show up, and it can be a real issue for people. YouTube user B. Crawford says, EEOC complaint case referred to as New York State Division of Human Rights Office. What does this mean? Okay, so the EEOC, the federal agency, cross-filed your case with the New York State Division of Human Rights. And often when that happens, the New York State Division of Human Rights takes primacy. They lead the investigation. Miss Tiff Tiger says, hey, I caught the live. Glad you caught the live. It's about to end. We're wrapping up. How long have we been going? Oh, we've been going almost 40 minutes. That's not too bad. We got 36 people and only 12 likes. Folks, the likes are how people find us in the algorithm. So I'm like required to ask you. I have to shill. If you could all hit that like button, it helps the channel. All right. So last you'll hear from me on that. All right. Tang Nguyen says, thank you for your thoughtful and important advice. Oh, that's very kind of you. It's my pleasure. I've listened to your YouTube channel for over 2 years. Great work. Thanks again. Well, thank you so much for saying that. That makes me feel great. I hope it is helpful. I will be honest, making these videos, sitting alone in a room talking to a camera feels ridiculous. And there's like so many angry people in the world, and I got a pretty thick skin, but it's just funny people being like so angry. You're just like, I just posted a video answering a question. It's all it was. Nia knows book says if the EEOC gets involved, then is what I'm asking for void, if the EEOC come up with their own amount. Nia, if the EEOC takes over your case, they're going to have thoughts on settlement, and they can often get in the driver's seat on that. Robert McGrath says, how many times can a pro se plaintiff file an SAC second round of 12B6, 12 count, 18 pages? Defendant's counsel said it is not plaintiff and short statement of claim. I'm sorry, Robert. I don't understand your question. But also, if I would hit up the pro se support office. I don't understand the question, but I would hit up the pro se support office. That's going to be your best bet. YouTube user Corey says, if I was written up for missing 5 days, but if you call your supervisor in, ask them to switch you off day to work, day you missed, it's fine. Is that a pretext? I don't know. I don't really fully understand the situation. If listen, if there's a discriminatory reason why they're terminating you and they made up some BS to get you fired, then yeah, that's a pretext. VA says, if an employer hires an external investigator for a discrimination complaint, is it safe to assume the findings will not be shared with employees? No. Don't ever assume anything. I would think they wouldn't generally, but you can't be sure. Is there a way for employees to get access? I mean, listen, gossip is the concern, usually. NYC Damages says, considering what you just said about mediation and the client not speaking, would it be wise for a pro se to bring someone else to do the talking? An attorney for hourly hire, possibly, or even someone who's skilled at mediation? Yes. So listen, I know that we have a lot of pro se litigants on the channel, and I've always said, I want good things for the pro se litigators. I want them to be happy. And like, listen, there are people who have done great jobs pro se and gotten big paydays, even like using this channel. And I love that for them. But let me be clear. The average pro se litigator is just engaging in self-harm. That's all it is. You're just harming yourself and your claims, and it's horrible. So NYC Damages, you're very savvy. I'm not saying that's you, but I am saying if you can have representation for your mediation, that is almost always preferable. Noriega, I was happy to look. I'm sorry I couldn't give you more information. That was a bummer. D's Just Joke said, have you heard of the Spivak law firm in Los Angeles? Yes, I've heard of Spivak. I cannot give you any insight. I don't know a lot about their cases, but I am familiar with that firm. YouTube user John Wong, my company committed some serious fraud. To them, the value of keeping the fraud from going public is worth more than my damages. Should I ask for and settle for more than any reasonable damages? Okay, John, let me, we have some videos on the channel touching upon blackmail, the potential felony crime of blackmail. If at any point you are threatening to report criminal misdeeds, if someone doesn't pay you, you need to be checking with a local criminal attorney in your jurisdiction, because often you might be running afoul of local criminal laws regarding blackmail. So listen, I don't know what the law is where you are, but I will tell you to be very, very careful. And listen, might they pay you more? Might they choose to pay you more because you know where the bodies are buried? Sure. Might you do some time if you give voice to that? You might. So I would urge you to get experienced and ethical counsel to make sure you stay on the correct side of those ethical and criminal obligations. And I would certainly recommend that. YouTube user Philip Morningwood says, "Have you seen someone greatly benefit from going to the press about their lawsuit?" I have. I have. Very much so. Yeah. I would not, if I didn't think it benefited certain people, I would not have dedicated some portion of my career to building that skill set. Is the best answer. Henry Best Believes says, during my suspension, I was a wreck. I told HR, my manager, I was seeking therapy, but there was a wait. I told them both I might need to go on leave of absence. All this cleared up. I believe this. All right. I believe you. Apologies. Needed a moment to blow my nose. John Wong, will simplifying the claim, which makes it public, hurt my chances of getting employment? How often do employers actually check civil lawsuits for prospective employees? John Wong, there are definitely employers who check dockets for potential hires. Many background check companies actually include that search. Also, Google, a simple Google can turn up a lot of what's on Pacer. So be aware of that. That being said, it can impact your employment prospects. It's a little industry dependent. Generally, most folks don't have trouble finding employment again, but it is always a concern. We have videos in the channel about quiet casing that you may want to hit up that discuss this more in depth. Pole 2011 says, have you ever had a client that you were working with, but the EEOC took it to litigation themselves? How does that work between you and your client? So, I worked at a firm once, not one of my cases, but I worked at a firm once where the EEOC did kind of take lead on a case. And I'll be honest, the client ended up just keeping the firm on and paying the firm, even though the EEOC was litigating. Because the EEOC is not so client-centric. They've got their own thoughts about settlement figures. They've got their own thoughts about process and timelines. And they don't necessarily care what the victim needs or wants. So, yeah, they did. They kept that firm on, even though the EOC was litigating it for them. YouTube user Corey says, I missed 5 days, but if you call your supervisor and let them know you are going to miss and you're going to try to switch and work on your day off to make up the day you missed, is that a pretext after complaining? I mean, not necessarily. If you just call and say, like, I'm going to try to switch, they don't have to agree to that, right? That's no so clear cut. If you called in and used sick days, that sounds legit, and that sounds like it would just be a pretext. So I don't, depends on what happened. John Doe KCK says, so if it has been 60 days or more since early mediation was offered by the EEOC and the defendant hasn't answered, does that mean that the chances of mediation are lower? The chances of that first mediation are lower. Mediation can still happen. And in fact, if a case goes on to federal court, there is in most jurisdictions mandatory mediation when the federal court case is filed. So be aware of that. I'm going to answer three more questions. Then I'm going to call it. I gotta get on my Zoom. YouTube user VA says, Vince, thank you for your videos and lives. Oh, live streams. Okay, got it. I have missed the last 2 lives and almost missed this one. Do you have a set schedule for your lives? If so, what is the schedule? VA, I do not have a set schedule. I'm going to try to do Friday afternoons. So I'm going to try to do like 4 or 5 p.m. Eastern time this Friday afternoon. I will post the notice in the channel. Yeah. YouTube user Chloe says, are intake sessions confidential? Yes. Or can an attorney get the information and talk to the opposing party? No. That would be an ethical breach. They would be risking their license and a lawsuit and a malpractice claim. YouTube user King Godsu, not to be confused with King Gosu, says, what would you say is the best option to keep a claim with MCAT or file a lawsuit in federal court? Listen, if you don't care about being public and you have good representation, federal court, 100% of the time. All right. Listen, I know there's other questions here. I'm sorry, not going to get to them all. I got to leave. This was a quick live stream. We only did 50 minutes. I'm sorry for that. I'm going to try to do Friday. I'm going to post the notice in the channel. Yeah, I'll post the notice for Friday. And I'm sorry I'm not getting to all the questions. I'm trying my best. Take care, everybody. Like, subscribe, comment down below, share our channel so it can grow. I got to say the things, right? Take care, everybody. Have a great evening. And wish me luck. I got to drive to New Hampshire after this Zoom.